This gathering is historic and unprecedented in perhaps two ways. It is the first conference in this country to bring together such a cross-section of leaders from the various spheres and branches of government to Chapter 9 institutions, non-governmental organizations, academics, representatives from the private sector, and leading jurists and legal academics from across the globe. But it is also historic because for the first time, it has brought together the heads of our three co-equal branches of government, the executive, the legislature, and the judiciary, to collectively reflect on our justice system. This underscores the shared responsibility that all three arms of our government have in upholding and protecting our Constitution. And that responsibility includes giving effect to the constitutional guarantee of the right of access to justice. Indeed, the Constitution requires organs of state, through legislative and other measures, to assist and protect the courts to ensure their independence, impartiality, dignity, accessibility, and effectiveness. The importance of the constitutional right of access to court cannot be gainsaid. By providing citizens with forums and peaceful mechanisms to resolve dispute without resorting to self-help, the right of access to court acts as a bulwark against vigilantism, chaos, and lawlessness. But our people would not be able to enforce these rights unless they know what rights they have. And I think in this respect, the media plays a crucial role in conveying what rights people have. And this they do by publicizing the disputes that are taking place in our courts. This is a crucial role because it makes justice accessible.
We have made significant strides in striving for access to justice for all our people since 1994. We have abolished many laws which were inconsistent with our Constitution. Our greatest achievement as a new nation in the 1990s was the adoption of a constitution which enshrines human dignity, equality, and the advancement of human rights and freedoms. In addition, the Equality Clause in the Bill of Rights stresses not only equality before the law, but the right to equal protection and benefit from the law. Esteemed members of the judiciary, while acknowledging the strides we have made, it is our well-considered view that there is a need to distinguish the areas of responsibility between the judiciary and the elected branches of government, especially with regards to government policy formulation. The executive, as elected officials, has the sole discretion to decide policies for government. This challenge is perhaps articulated clearly by Justice V.R. Krishna of India, who observed that, and I quote, "Legality is within the courts, within the court's province to pronounce upon, but canons of political propriety and democratic dharma are polemic issues on which judicial silence is the golden rule, unquote. This means that once government has decided on the appropriate policies, the judiciary cannot, when striking down legislation or parts thereof on the basis of illegality, raise that as an opportunity to change the policies as determined by the executive area of government.